Good morning, everyone, and I hope you can hear me. Last time I started a webinar, I forgot to unmute myself. Good to see everybody here. I'm going to just pop in for a quick moment to say hello, introduce myself, and to introduce my partner for today, and also review a couple of items of housekeeping, just to go really quickly. So let's do a couple things. First off, I'm going to be joined today by Kathy Marks. She is, I would consider a COVID specialist and expert. She's drafted tons of policies, COVID protection plans, and she was the first one to start doing this back in March of 2020, and she was sending these out to our clients for free. So Kathy, do you want to say hello to our incredible Heffernan audience today?
I do, everyone. Welcome to our webinar today. Every time you say that, Steve, I get the Dancing Queen song in my head, being the COVID queen. So I don't know if that's good or bad, but thank you for that introduction. And I will be back in the sidelines supporting you today.
That's right, folks. As part of our session, you're more than happy to ask questions throughout. Kathy will be taking those. And for those that seem, that we need to get a larger audience in place, we'll do them. And she can also interrupt me as I'm going throughout the presentation to ask a particular key question. On your screen, I'm going to go ahead and take care and remove myself now so that we can get right into the presentation. Good to see everybody. A couple of things that I want to share with you is that Heffernan has a great series of webinars set up for 2022. And you can see here that if you don't have this already, we'll be sure to send this link out to you afterwards. But they've got great series throughout the year, and always valuable information is spread among their Heffernan compatriots. So with that, let's get started on this, and let's get our presentation up and running. All right, BUILD is, I would say, one of the most substantial legislative developments since the pandemic began. The OSHA ETS, or the Emergency Temporary Standard, requires either mandatory vaccines or employ, regular testing and wearing of a mask for those that are unvaccinated. Although this standard is written for employers of 100 employees or more, there are lessons to be learned from this, and we still don't know what the outcome of this will be. My name is Steve Thompson, and I'm a Senior Vice President with Aspen Risk Management Group, and as you've already met Kathy Marks, who will be my partner on this session, answering questions and behind the scenes. And this will be interactive, as we mentioned right out of the gate, so bring your questions, use your question or your chat box. Most of you will have both. If you're calling in from a phone or a tablet, you may need to tap on the screen to pull that up. All right, quick disclaimer, always have to have one. The information is current as of November 23rd. We have some breaking news that we'll share with you in a little bit, but as of where we're at today, this is as current as we can possibly get. So there will be a recording of this that's set aside for the Heffernan team, and it's just important to note that this is a very quick changing set of circumstances, and you can see the listing of the other organizations that are involved. So lots of happening. Our agenda is pretty quick. We're going to cover 4 big sort of ticket areas of discussion. We'll talk about the legal challenges that exist today, and then we'll talk about the meat and potatoes of the legislation, what it means, etc., what your options are, what the rules surround those. And then we'll talk about the cultural and the operational considerations. I think one of the things that we talk about the standards so much and what's involved and what it does and how we have to comply, but we miss the aspects of what this does to our organization, and it's important to recognize what kind of company that you have. We have a polling question, as if any of you have been to a Heffernan webinar before, you know that we like to ask questions throughout. So I'm going to go ahead and pose our first polling question. We just want to learn a little bit about you so that we can apply, maybe talk about your industry a little bit, but go ahead and just share with us about your, what kind of organization do you work with? And we'll just give this, we usually give this about 60 seconds, so we'll do the same thing here. And a great audience today, Kathy, just voting terrifically quick. We always find that with our Heffernan audience, just incredible. So we want to thank all of you for taking that vote. And I'm going to close this. And then if you didn't get a chance to vote, you know, you just work quickly next time. You'll have a chance to get your votes in. We like to go right up to the about a minute in length, giving everybody a chance to vote. So let me go ahead and close that. Let me share that with you so you get a sense of who you are. So you know that the fellow hundreds of you that are on this call today, 24% of the government, municipality, or nonprofit, 4% of the insurance industry, 51% for for-profit companies, 2% schools, and then 19% other. Thank you very much for sharing your information and your poll, and we're going to go ahead and move on. Okay, there are a number of legal challenges, and I won't go into every single one of them, except to say that the OSHA ETS has been suspended for the moment. That's because the Fifth Circuit, this is the United States Court of Appeals, essentially said, you know, there are a lot of legal issues with this, including constitutional issues. We're putting a block on this. OSHA responded and said, absolutely, we won't proceed further. But that was the beginning of sort of the next stage, which is all of these 34 lawsuits that have been filed on this against the ETS are now, or against or for the ETS, I should say both, because in some states, some organizations voted that they wanted it and filed suits to keep it in place. That this is all now down to the Sixth Circuit, which is a little bit more conservative court. And the most recent update on that is that as of today, not only, of course, has OSHA suspended the enforcement of the ETS, but the Sixth Circuit has now combined all of this information together, but it hasn't stopped other organizations to want to keep it going. For instance, the administration has asked the appeal to reinstate it, just move forward. So we put a link to the court case and the lengthy documents that exist for that, so that if you're interested in that. So as of today, the OSHA Emergency Temporary Standard is on hold, but we don't know where this goes next. And we'll have some suggestions at the end as to what we think is the best course of action, you know, given the information that we have. Okay, there are some legal hurdles that I want to just quickly go through with you so that you have a sense of what's happening with this ETS. It's the first vaccine mandate in OSHA's history. You may have thought that the one they did in June for healthcare required vaccinations and testing. No, healthcare workers were not required to be vaccinated or to be tested. However, many companies opted to choose that under the EEOC to be able to choose for their employees to be vaccinated. So this is the first time vaccines have been required in their history. ETS is rarely used. You know, the last one that passed was 1983. So in 38 years, we've only had two more, the last one in June and this one, you know, that came out in November. The other thing is that the healthcare ETS doesn't require vaccinations. So why would this one require vaccinations? That's one of the legal hurdles that's there. And then you can see the rest of these that I won't go into any, you know, particular details on. You'll have them because you'll have a copy of the presentation. But is it really a necessity, which is what is an emergency standard, based on the fact that we had COVID cases going back to March of 2020. We probably peaked in 2020 with cases. And so why wasn't the ETS written back then? That's sort of one of the legal challenges. And then there's a whole bunch of others that I don't want to go into. We don't have the time to do that, but want you to be aware of them. All right, we have another polling question for you, and we'd like to get a sense of how you rate your OSHA COVID regulatory knowledge. How do you feel you stack up as it relates to your COVID knowledge from a regulatory perspective? Maybe you've got a great background on the healthcare side, but we really want to know how you feel, your confidence level from an OSHA perspective. And again, wow, great audience. 70% already voted. That's terrific. It's in 25 seconds. Again, What a fabulous audience, just so responsive. Thank you so much. All right, we're going to give this just a few more seconds when we reach our 80% goal. And thank you all for typing in your information. And again, fastest responding folks in the country, the Heffernan team of clients and prospects. All right, let me close that out and let me share that with you so you get a chance to see where you're all at. We have some awesome experts on the call. So for those of you that are awesome experts, we hope to hear your input and certainly provide that to Kathy through your chat or question box. And then 43% about on par. Some of you are in the early stages, 32%. And then we've got 16%, a little more than most. We hope to hear from all of you. Quick summary of the standard. Well, at the end of the day, it's to protect the unvaccinated employees of large employers from the risk of contracting COVID by strongly encouraging vaccination. That's in the opening paragraph of the standard. That's the reason it was written. And then there's a whole bunch of stuff that goes along with that as it relates to developing a plan and all of the other things which we're going to cover in detail. What's temporary? Well, this is supposed to be done by the end of May 2022. An emergency standard is supposed to last 6 months. And the goal for OSHA is to get in their statement is to get as many people vaccinated in the workforce. And then depending on the circumstances about what's going on with COVID and what's happening with vaccination rates, they'll determine perhaps before 6 months to make changes. That's how the standard is written. The justification that OSHA provides to us as it relates to, why do we have this? And that is that the workplace poses a grave danger to unvaccinated workers. And that this standard is absolutely necessary to protect unvaccinated workers from risk. And then a whole bunch of other stuff, as you can see here, that employees becoming seriously ill from COVID, and that vaccinations can largely prevent deaths and illnesses. This is within the standard. These are quotes. I'm not saying this from a point of reference other than a point of the code. And that ETS protects those who remain unvaccinated through regular testing, use of face coverings, and removal of all infected employees from the workplace. Those are the quotes from that. Well, what is grave danger? Well, grave danger prior to COVID was something completely different when it came to chemicals. Usually these grave dangers involved aspects of jobs that involve, serious chemicals or exposures, and usually affects all employees, not just those at 100 with employees of 100 or more. But in the case of the ETS, they describe that the grave danger is incurable, permanent, or fatal, as opposed to easily curable, blah, 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 and fleeting effects on their health. So in this particular case, they're describing grave danger as something slightly different that was used before. But again, that's why one of the legal hurdles is, can they overcome the fact that is this an actual grave danger for employers of 100 or more employees? And the purpose, of course, are vaccines, verification of vaccines, face coverings, and testing requirements. And this is the part that everybody has asked us along the ways is how does this relate to my state? I'm in Illinois, I'm in Washington, I'm in Connecticut, I'm in New York, I'm in California, I'm in Texas. It doesn't matter what's existing in your state. The OSHA ETS will override and preempts all state and local laws. Now, states have, if you have an ETS in place in your state, and many do, you have existing laws that are in place to protect employees from COVID. This standard will override that, and states have a period of time to draft a policy that is equal to or more strict. We'll get to that in a moment. Let's first look who's covered under the standard. We've all been heard the 100 or more. How does that work? Well, on December 4th, if you have 75 employees, the standard doesn't apply to you. But any time during the next 6 months after that, through, again, the end of May, If you reach 100 employees, you have to start practicing within as if your company has to comply with the ETS. So it doesn't matter if you're 75 now and you get to 100 or more at any time during the ETS. If you are 150 employees today on December 4th, when you go into the standard, and you drop down to 75 sort of halfway through, you can't back out. You're in. So if you went from 150 employees or 200 or 10,000 employees down to 25 employees, it doesn't matter. You still have to comply with this standard, regardless of what your current status is, depending on the circumstances. Now, the interesting thing that's done a little bit differently here is that you don't use full-time equivalents to count your employees. So for instance, when you are calculating your OSHA incident rates and other aspects, you're using hours and you're using full-time equivalent of employees. In this case, you don't. Everybody's counted as a full one employee. So it could be a part-time, it could be seasonal employees, it could be full-time, of course, or provisional employees. And remember that staffing company employees, unless the payroll's under your company, they would be counted separate. And of course, independent contractors are not included also. All right. The one thing that Kathy and I have seen in the recent OSHA inspections, and we're asked numerous times to respond to OSHA inspections for our clients, and that is the question that is, how many total employees do you have, in the U.S. in your organization? This is a new question that we've seen come up over the last year in preparation, we believe, for this standard or standards like this. Because it used to be OSHA would come out, they'd come to a location, and if you had other locations, it wasn't one that they would be writing a citation for. Now, some states, and there will be some changes in the way OSHA citations are designed, that you can write a citation in one location and apply to all locations. So one of the things that OSHA is questioning, and one of the parts of the ETS standard is, you have to count up all your employees within a given corporate entity, even if they're separate companies, if they sort of fall under the same umbrella. So for instance, if all your work comp policies are generated, even though you've got 10 different companies, the total number of employees under that corporate entity would count. If you're a franchise operations, let's say you own 20 restaurants, well, and you've got, a total of, 1,000 employees in those restaurants, but only 75 at one of them. Well, OSHA is going to want to know how many you have at all of those locations. And you don't want to, let's say you have them all set up under a separate LLC or something like that. OSHA is going to be looking for your total number of employees within that entity. So under span of control. So just be aware that there are some differences to the way that covered employees are dealt with from a count perspective. As I mentioned before, I believe there's 28 right now independent. I know that Florida's talking about becoming their own, having their own OSHA, but at this point in time, there are 28 individual states that have varying state plans. Some of the plans cover private and state employees. Some of them only cover state and government workers only. So you should know your state plan depending on where you're at, and you should have an understanding of how this plan applies to your workforce. And the way that OSHA describes this is that a state plan has 30 days to comply with a federal plan. So what you saw happening in the states that have their own plans is they all were getting on the docket in the last couple of weeks to take a vote on what they're going to do and to draft their plans. And some states have postponed those dates, simply saying that we have to wait now to see what happens. But many states have already postponed those meetings because most of them were just going to adopt the standard. Now, if you're in Washington State, you'll see what the governor recently said. Although they are on a pause, they wanted to draft an ETS that was more strict than the federal program. And the states have the right to do that. They can't do it that's less than that standard. They have to either make it equal or more, or more stringent. Well, let's see where the aspects of the ETS don't apply. Well, certainly if these are work locations with only one person or no contact with other people, that certainly would not be, applicable. If you have somebody working from home exclusively, alone, of course, not with other employees in that virtual environment, people working exclusively outdoors. Now, if you have people that drive to a location, like if you're in agriculture or landscaping or construction or plumbing or any of these fields of work where they have to drive together in a car, that's going to perhaps exclude that option, meaning that although they're working exclusively outdoors, now people are in vehicles together. That's a different set of circumstances. De minimis. Now, de minimis is a term that's used in a lot of different ways, but from an OSHA ETS perspective, if you have a person who works exclusively outdoors, but they have to come into an area maybe to punch their time card or have a meeting with the boss or something like that, and they're only in for a short period of time, they're still covered as, under the plan, but they could be excluded as an outdoor person as long as they don't have a lot of exposure. Now, the way the plan is written, it says that these employees will be, the OSHA officer will determine what that is. The CDC states that, sort of de minimis, they don't use the word de minimis, but they say that it's 15 minutes of, exposure within 6 feet of another person, 6 feet or closer, for over 24 hours. So that's de minimis in their minds is 15 minutes of exposure closer than 6 feet within the 24-hour period. Not something for you to have to worry too much about at this point in time because the standard is not in place, but you may have state plans that already have this in place. And then the only other people that are waived from the sort of testing piece, if you decide to go that path, are people who have been diagnosed with COVID within the prior 90 days. That's because their tests may come up positive. There have been a number of false positive tests for people who have recently had COVID. So they're waived from the testing environment. Key dates, you got to have a policy in place by December 5th. You've got to have these other aspects, permitted time off, allowing paid sick leave, etc. And then by January 4th, those people who are not vaccinated must be tested for COVID. So the plan happens pretty quickly. I've put a slide here that shows the key dates. I'm not going to go through them because you'll have this as a print off and available to you. Everything, of course, is due on the 4th of December, except for the being fully vaccinated is not until the 4th. Now, again, this ETS is on hold, so we don't want to, we don't want you to feel like there's an urgent need to take care of this right away. But we'll have some suggestions at the end about steps to do. Now, here's where you have a choice. You have the choice to have a policy that includes vaccination, testing, and face covering, or you have a policy that is mandatory. So you have one that allows you to have a choice for your employees, and you have one that really doesn't allow much of a choice. The other thing is if you already have an existing COVID policy, this is the time to review it to see how it matches up with what we described today. There are some templates that we'll be providing to you that are from the OSHA page. We ask you to beware, though, because they're written from a regulatory perspective, not from your company culture perspective. So be very careful in the way that you write those, and we'll talk about that in a little bit. All right, another polling question for everyone. Let's just pop this one out there. This is the one that, that probably a lot of you are curious about. Do you plan on requiring vaccines or already have vaccines for employment as a condition of employment, for employees as a condition of employment? So we'd love to hear your thoughts on this. Do you plan on requiring vaccines, or already have vaccines, for employees as a condition of employment? We're going to give you some time to think about this. This is one of these questions that is a challenge, and we're going to go ahead and give you all just a few more seconds to do that. We're almost at 80% voted, which is usually where we cut it off, and we're going to give you all just another 10 seconds or so. Okay, let's go ahead and close this poll, and let's share it with each of you. So, wow, really close here. We've got 38% no, you will not be making vaccines a condition of employment, 33% yes, and then 29% not sure at this point in time. Clearly, this is a mixed, dilemma for many companies. Thank you for sharing that. Okay, so what about the cultural and operational aspects of whether or not you have, a choice policy or a mandate policy? One is that you're endorsing vaccine choice. The other is you're endorsing basically a vaccine mandate. So what is that statement that you will make to your employees, your customers, your vendors, etc.? And this is a part that every company has to make the decision on. And that's why this is such a difficult and challenging aspect of this particular mandate. We've included some sample statements that, depending on which way that your company will be going or is going at this time. One is a sample statement that you could make for endorsing choice, and we're just going to provide this. I'm not going to go through it in detail. It's basically saying, our company believes in safety and health, and so therefore we want people to make their own decisions with the vaccine. And then we have a sample statement endorsing the vaccine, which essentially says the same thing. We support safety and health, and so therefore, in order to do that and for the well-being of our employees, we're endorsing a vaccine mandate. So there's two sort of possibilities here, and we've just provided those so that everybody has those available to them should they want to make a statement and struggling with the language or having some challenges in that area. So let's talk about the things that are very similar in these policies. I love those cute little dogs there. There is a requirement for vaccination in the policies. Of course, you can have exemptions and testing and masks, of course, with these policies. You have to allow for the exclusions. And we've talked about what those are already a little bit. Each policy requires that there be a determination of vaccination status, whereas you have to ask and you have to document that. Each of them have paid time off to get the vaccination. You've got to provide that. Each of them, of course, are when there's a positive test and a person does test positive to be removed from the workplace. And then you've got to provide information to employees about COVID, about testing, other aspects of it. And then some sort of disciplinary action in place. That's the challenge that you want to make sure that you deal with real carefully in these template plans. We always suggest that any safety plan at all, whether it's a state that requires a specific plan or otherwise, that your disciplinary action line up with your HR handbook and all of your other particular pertinent policies that you have that describe discipline. You don't want to have a different plan under COVID for discipline than you do in your HR handbook for various items. Although we're seeing Justin Timberlake there, and his hair does look like a ramen noodles, there are some differences. Of course, the mandatory policy requires a vaccination. The non-mandatory requires tracking, testing, and face coverings. And new hires, either way, generally have to be either fully vaccinated, or a process in place to do that, or tested before they come to work. And they both allow for accommodation. We noted that when we read through this, in addition to the, some of the legal hurdles, that the OSHA ETS actually doesn't match up with the CDC guidelines for workplace safety. They either miss that or they're taking a little bit different path. Generally, OSHA will refer to things like NIOSH and other standards as it relates to safety. In this case, they do refer to the CDC, but they have a difference as it relates to vaccination, the wearing of masks, and distancing, of course. All right. These are the critical dates, and these are the things that you have to have in place for the mandatory vaccination policy. We just wanted to break this out so it's real simple from that perspective. So If you're one of the companies that's doing the mandatory vaccination policy only, these are the components of that policy that must be included. And of course, all of this is pretty standard stuff that you've read about or seen about. That is, of course, you have to have the dates and the deadlines that you identify. You've got to make sure that you determine the vaccine status, how employees submit their vaccine information. We'll talk about that in a little bit. What accommodations are you making for employees? You have to make medical and religious as part of ADA Title VII. And then what process do you describe to them about PTO and sick leave when people are getting a vaccine or they have a reaction? And then what do you do with positive tests, and how does someone leave the workplace? And then what are those consequences when someone doesn't follow the rules that you have? The other thing that's come out more recently is that there can't be retaliation against someone. Let's say that you have a policy and they do have a religious exemption. There can't be a retaliation against that person because they have a religious exemption. And there can't be retaliation against employees that either are vaccinated or unvaccinated. So if you have a company that has a mix, there can be no retaliation against employees or new hires. Let's not forget that. You can't have applicants that you would be biased or prejudiced against because of one having vaccinations or not. Okay. Now, if you choose the choice policy, which includes vaccination, testing, and face covering, certainly all of the standards that apply within there, but these are the things that have to be included in the policy. Of course, any notice of a positive test, still with the consequences, still that anti-retaliation, except that you do have to have, of course, all of the aspects of the testing and the face coverings and that. We're going to cover that. Now, what about record keeping, and how is all this process in place? So you have to have vaccination status of your employees by December 5th. Now, you may say, we don't want to ask our employees if they're vaccinated or not. We want it to be a complete choice. That's a different path that we're not going to discuss today, but if you are interested in that, you certainly can reach out to us. The reason is that this ETS only allows for two possibilities. One is to do the mandated vaccines, and the other is to do an option of the vaccines. But both policies require you to inquire the vaccination status of your staff if you're 100 employees or more. Proof of vaccine. You've got to have some actual proof. It just can't be, yeah, I had my vaccine. And it's got to come from a healthcare provider or some sort of other, medical immunization record. There are some online programs that exist. I have a record card, or again, a digital COVID test result. And then you could have other records that exist, the companies that are offering, but in essence, there's got to be a proof. Now, if an employee, let's say they were vaccinated quite a long time ago and they don't have their card any longer, or the process was a little different, you can have them do a self-attestation, which basically says, I got my vaccination at this time, they sign, they date it, all the information they can remember. But they have to, the form has to say that if they provide false information, they could be subject to criminal penalties. So there's a form, and we've included a link to sort of the language for that. And that's a critical aspect of the self-attestation. Vaccination status has to be treated as medical record. This does not go in an employee's general file. It doesn't go in their HR file. This goes to same sort of filing that you would any other medical information. You've got to have a roster and a database. You keep that confidential, of course, of the vaccine status of all staff. Let's say that you had people who were vaccinated prior to the standard. Well, those are still accepted. You don't have to go back to your workforce and ask them again, as long as the way that they have provided that information fits with the current ETS. So you've got to have a record of it. You've got to have some sort of, you can't just have someone saying, yeah, I had the shot. And then, of course, you've got to maintain the results. We do not recommend badges or any kind of identification that employees would carry that shows whether or not they're vaccinated or not. That can create some dissension in the workforce. Certainly not something you want to be dealing with. There also can be some legal liabilities associated with that kind of identification process. Well, testing is done, and these are the types of information that has to be done when the tests are there. The employee's name and then another identifier. Generally, that's like the date of birth. Got to have the date when the test was done, the type of test, whether it's a PCR, otherwise, and then who did it, and then of course the actual results. From a record-keeping perspective, if you are a company that's not exempt from keeping OSHA records, this has to be on your OSHA log when it's a work-related case. So not every positive case that your company has would be reported on the OSHA log. This would only be done after you have learned that the case is, potentially work-related, and you do an investigation, doing, standard investigative protocols to determine if it's work-related or not, and of course, if it's beyond first aid. Secondarily, it doesn't matter whether you're exempt from the OSHA log or not. You have to report, as you do with other types of cases, any fatality to OSHA within 8 hours of learning of the case. So let's say, for instance, some time has gone by. Maybe it's been a couple of days. You've had to conduct an investigation. You have to find out, what did this happen at work? There is that allowance by OSHA by using the term learning of the fatality or learning of the inpatient hospitalization. So a little bit different than when somebody is hurt on the job, and has a fatality. You've got 8 hours from the point of that fatality. In the case of COVID, you've got a little bit of flex, but be careful. You don't want to, press that too hard. The requirements for unvaccinated are laid out here. I don't need to kind of go through those, but one of the points that is important to sort of note is the testing has to be done every 7 days. OSHA doesn't say, that it has to be done, the day before a person comes in. It has to be done within those 7 days prior to a person coming to work. So if they're coming to work on a Monday, they would have had to have that negative test result in the prior 7 days. And of course, the tests have to be the FDA approved. Remember that the testing, the way that the tests are being done are going to change in January of 2022. Tests must differentiate now between influenza and COVID. All previous tests did not differentiate between the two. So that's a change starting in January. And then although that many states are requiring cycle threshold results, like Florida and others, there isn't a mention in the ETS if that's required. So there are some differences between testing vaccinated employees versus unvaccinated, but that's generally up to the state. And so if you need to have that information as part of your state plan, you want to make sure that you get that. It's got to be observed by an employer or telehealth. And somebody asked a great question in the webinar that Kathy and I did before on what is telehealth. Well, we're not exactly sure what it is, but it's, as the FDA describes it, it's a person who has been trained and has the knowledge of being able to proctor, observation of taking the test. And we don't know if that could mean, on a video or not, as long as all the procedures, I say digital or virtual. So far, that's not hasn't been revealed, but it could be someone that goes to someone's home and witnesses the person doing the test and then takes that off, in the package and takes it off to the lab. Pool testing is allowed, and if you're not familiar with that, let's say you have 20 employees working in a particular area, and you take the tests of all the people, you just take the swabs of everyone, and it all gets pooled into one test. And of course, if somebody tests positive, you got to go back and figure out, you got to retest all of them individually again, but you could take them all together, and if of course they're all negative, you've just saved a lot of money in doing pool tests. So what are the options for testing? Someone had asked this question in a previous event, and certainly you want to first check with your healthcare and occupational providers. There's still a lot of money out there and free testing going on, And so you may want to, as a company, do a search in the areas that you're operating where you have free testing for your employees. National firms are offering both pooled and individual testing. You can see the big players like Quest Diagnostics and others coming up with plans, for testing. And of course, large retailers like CVS and others, they are doing, they'll provide on-site testing for your companies. They'll come out one a day a week or otherwise, or at all their retail locations. And of course, many employees are already being tested, those that are under mandates, through their healthcare providers. Now, not everybody has healthcare that might include that, but a lot of them are already being tested in that way. That's the 1918 pandemic. We'll talk a little bit about face coverings. Face coverings are required unless outdoors, alone in an enclosed room with floor-to-ceiling walls and a door, eating, drinking. You've probably seen these standards lots of times. We won't go through them, in extensive detail. What does it mean if an employee requests an N95 respirator or they choose to wear an N95 respirator? Well, for many companies that have just never dealt with this, industrial companies a lot of times deal with respirators, but many companies have never dealt with respirators before. And if an employee says, I want to wear my respirator, you're required, depending on the state you're in, of course, but if you're under federal guidelines, you would have to provide that employee with the information of the OSHA Mini Respiratory Protection Program. And that provides information to the employee about how to clean, how to store, what they might want to do from a medical perspective, like making sure they don't have heart disease or lung problems while they're wearing it. But you don't have to actually do any testing or any respirator fit testing or medical testing for those people. And it's the same if there are a lot of you from California. It's Appendix D that you have to provide to the employee. Now, if you provide the N95 to the employee, that changes the whole story. Meaning that you're saying, I'm going to provide you this respirator, then you have to provide the full-on respirator protection program. You can't get away with the mini plan. Now, then you have to go full-on in with your respiratory protection program, written program, testing, medical testing, etc. So just be aware of the differences. We've identified some of those here, what they look like if you haven't seen them before. There's also companies advertising something called K95, which is a Chinese designation. It's not the same as N95. Don't get caught up in buying K95 masks. And then we've included a little bit how to wear the masks. Okay, if somebody tests positive or is diagnosed with COVID, there are a number of steps to take, and each state has had their own, but let's talk about the ETS. Certainly employees are, required to promptly report it. And then employees have to be removed. And the way the ETS is written is that the employee has to receive a negative PCR test in order to return to work. They also, or they can meet the return to work criteria from the CDC we've included in the link. Now, this could be a recommendation from a licensed healthcare provider. Now, the CDC has a 10-day period of time that the employee has to be, away from work. So if they test positive, they have 10 days that they have to stay away. Now, there are variances to that. Some states have essential employees, and that goes down to 7 days, or some states have a 14-day period of time for quarantine away from work post positive test. Important for you to know if your state has something different. The penalties are pretty clear. They're known as a serious violation, which is $13,653. What I was going to share with folks before is I have a link here to all of the OSHA related inspections that they've done and the fines, and it's about $4 million since July of 2020. And you see probably 80% of the citations are respiratory protection. It is important to know that the Congress is currently evaluating a bill called Build Back Better. And it does increase the cost of OSHA fines for serious to $70,000, and a serious and willful, which would be $130,000, will go to $1.3 million. So important to know that, under the new bill, this could change if that bill passes in the way that it is. Of course, there's an exemption process, and it's important to understand that employees with qualified disabilities or medical conditions or religious, they have the option. They should be provided the option of an exemption. Employees don't have to use, quote, magic words. That was right in the standard. Magic words are like, I want a religious exemption and I have a sincerely held religious belief. No, you don't have to use all those words if an employee requests. They can be in their own wording. Hey, I have a religious belief that I shouldn't be that I shouldn't have to receive a vaccination. And they're going to have to write that out, of course, to describe that, but it doesn't have to require these magic words according to, according to the EEOC or the OSHA ETS. Reasonable accommodations, that's where you have to provide employees, a reasonable accommodation. We've listed some examples of accommodations. You don't have to eliminate essential job functions. You still have to you can still require all the job functions of that employee. But let's take a look at some of them. Use of face covering, keeping away from others, testing for COVID-19, providing telework or telecommuting, staying far enough away from other people. These are just some examples of accommodations. But the key is, of course, it can't be an undue hardship on you as an employer. And this is a gray area because it says, well, how much can I spend, if I have an employee and, should I spend $1,000, $10,000? What can I spend on an employee? Well, some employers are saying, look, if I have 20% of my workforce that exempt and I have to spend a cumulative, $2 million to accommodate them in the workplace, that's not a reasonable accommodation on behalf, the way that the EEOC or the ETS would review that. So this is a little bit of a gray area. They usually say it is de minimis, meaning that your investment has to be de minimis. But my suggestion is to go the Job Accommodation Network, JAN, and take a look at what the accommodations can be structured and how much you should be willing or could be willing to pay from a financial or an operational perspective. And remember, if you've had religious or medical conditions before at your company, and probably not too many. I mean, none of us have really dealt with religious exemptions before in any kind of mass scale, but you want to be consistent. If you've set precedent before, or you are now setting precedent, you've got to be careful that you do the same for everybody, of course. Now, do you have to provide employees with paid time off if they're removed from the workplace? No, you don't have to do that. But they may be required by other laws or any collective bargaining agreement that you have in place. And what about paid time off for vaccinations or if somebody gets sick from the vaccination? Well, you've got to provide 4 hours PTO time. If they're a brand new employee and they have no time, you still have to provide that time for them. And the ETS standard is given a little bit of a flex. They've said, well, most people have had up to 3 days or so of side effects to the vaccination. So it should be fair to give them 2 days off of paid sick time if they have a side effect from the vaccine. It's not saying you have to do that. It's what ETS says that they're looking for. They don't make it a firm number, but if the OSHA officer would provide, be looking to give you a citation and you've given no time off, that could be a gap in your policy. And remember, if an employee becomes ill with COVID, you don't have to give time off, but you have to remember if it's work-related or you have state requirements like in California or you have a collective bargaining agreement, you got to pay for that time. That we've already done that question. All right, what do you do now? Because the ETS is definitely in limbo. You have the administration asking it to move forward as of today. Please, Fifth Circuit, please, while you're in your research, let this standard go through. And then you have the Fifth Circuit that's combining all of the 34 lawsuits. And I put a link to that in that page previously that shows you what they are. So what do you do now that this is in this stage? and could end up in the Supreme Court shortly, or it could go one way or the other at any time. We cannot predict this. So first you want to determine if you meet, if you have 100 employees as of December 4th, where do you fit? If you don't, okay, then you're sort of exempt from this standard as it exists. But remember, your state might not put a 100 employee threshold. They may say all employers, we don't care how big you are, have to comply with this standard. That can happen. You have to be very aware of that for your state. You want to review your current COVID policies. You may already have a mandate, or you may already have testing, or you may already have distancing and other safety procedures in place. Maybe you have a lot of things already going. You want to compare that to the templates, and you want to make sure that we'll get to that in a moment. You want to review your policy options like mandates. Do you want to do a mandate, or do you want to have choice? Gather your relevant resources. We put a ton of them on here for you to take a look at. And draft a policy. Pull one up of these templates and be very careful, because, for instance, they'll talk about a religious exemption and following the regulations of the EEOC and Title VII and all of the aspects. But the important part of this is that you, as a company, can determine what is a religious exemption. If a person comes to you and says, I have a religious exemption, and you want to provide that by just someone coming to you saying that, you can do that as a company. You don't have to follow, the firm of the law which says what you have to do. You just have to make sure that if that's your precedent setting, that if you want a religious exemption, all you have to do is check this form on this box and says, I'd like a religious exemption. And you don't have to go any further. Now, some companies are going much further. They're interviewing employees. They're asking them about their faith. They want to know where they go to practice their faith. They want to know their history. You don't have to do that if that's not if that's not in alignment with your company culture. And keep abreast of the latest activities. I put the most links from the National Law Review and then JD Supra. And then if you want to link to me, you can do that. I've been keeping up to date on this and posting. If you make 10,000 regulations, you destroy all respect for the law. Winston Churchill, pretty wise. Let's say you want to say something about this. Well, you've got until the end of the month to comment on this, and there's a link there. And we've provided not only the ETS documents, PDF, instructions. We've actually put the instructions for compliance officers that they've written for the ETS. We've given you that link there. And then, of course, all the other stuff that goes along with this, including all the fact sheets, including the ETS video that the government, put together. And just remember, when you're reading all this stuff, it's all from their perspective. It's sort of like if you were to go to a casino. Remember, everything is set up for the casino's benefit, not for yours. Just remember that all of these documents, everything is set up for the benefit of the government, not for your company. That's why culture and operational aspects are critical. The resource pages, we put both templates in there, and then, of course, the link to the EEOC that talks about why it's illegal to ask why it is legal to ask applicants about their vaccine status or existing employees, et cetera, et cetera. All right, I want to thank everybody for being a part of today's session. We've gone through this pretty quickly. We love it if you can put a takeaway in your question box. What's one thing you took away from today's session? And also a chance to answer any of your questions that you may have. And before we do that, I just want to say that after the session is all over and we close out the webinar and you've moved on, we've got a 10-second survey that we'd love you to participate in. It's going to ask you how we did today. It's also going to ask you how we can make this better. So Kathy, do we have any questions for our amazing audience today, or any takeaways you want to share?
Okay, first off, I want to say that Heffernan clients are amazing, and they have been keeping me, my fingers are flying, and so I think I've answered a lot of the questions, but Steve, I need you to review the testing. We're getting a lot of questions regarding the testing, and I don't know if you know them offhand. It's hard for me to kind of control F in some of the form. So let me just tell you, it's about our rapid at-home testing allowable as long as the company oversees it. So let me just tell you what we've got about testing. So our rapid at-home test allowable as long as the company oversees the testing. One question is testing waived for employee who had a diagnosed case within the last 90 days. So does this mean employees will need to provide weekly testing after that 90 days? Is it okay to provide to employees the quick tests you acquire from a drugstore? If you remove your employees from work due to positive tests, are you required to pay them?
Let's take one at a time.
Let's just talk about testing. Yeah, those are mainly the testing. Okay. I can answer the other one.
Yeah, so let's take the testing one at a time. So the ETS standard talks about the types of testing that will be required under this standard, and they will allow rapid tests, they will allow PCR, they will allow NAAT, they will allow most testing that's done. The issue that comes up is whether it is self-administered and self-reported. What they go into detail on is the self-administered, self-reported will not be allowed. So if they do have a test that is, that they can take home, which is fine, but it's got to be proctored in some way. So we talked earlier about whether or not this is going to include some telehealth component. We don't really know what they mean by the standard. The way it is right now, the FDA decides that if a person wants to take one of these tests, that it has to be done by someone witnessing. It could be at the company by an employee that checks off, that's had experience and has been trained on how the process works. So it can't just be an employee who says, yeah, they've all done their tests, it's all good. No, you've got to look at the FDA guidelines on what it takes to be, Kathy, we use the word, competent person? You can't just be a person that says, well, yeah, they did their test. You've got to look at the FDA guidelines on competency. So I don't want to, take away from that question, but the big key part is self-administered, self-reporting. That's not allowed. And then they question about the testing resuming after the 90 days. That is correct. Once the person is past the 90 days of a positive test, testing does resume. What were the other questions? I'm sorry, there were a couple others in there, Kathy.
Yeah, it pretty much, so I think I'm getting a lot of detailed questions that I just want to share. So remember, if you are in California, California has an ETS standard in place. It does not have an employee threshold. It applies to all employees, and I've sent the link for the facts. So what we are talking about in this webinar is the proposed Fed OSHA standard that is more stringent than the current Cal OSHA. And as Steve said, states have to be as stringent or more stringent than Fed OSHA. So if you are in California, because the Fed OSHA standard has been put on hold, you still follow the June 2021 ETS emergency temporary standard that was put in place. So I'm getting questions that are kind of a little bit of both. So,
okay. And that's great.
Right.
And Kathy, let's do this. So for those people that have asked those questions, we're going to make sure we get back to you. And what we can do is when we send our copy of the presentation and all of that, we can put those questions in the follow-up email and we can answer them. Yeah. We don't want anybody to be at a loss here for the issues. Any others that sort of have popped up that may not involve the state?
Testing, yeah. So again, they're getting kind of, so I do have one. Okay, so December 5th is a Sunday, so does the standard need to be ready on the 4th or the 6th? Remember, the Fed OSHA standard is on hold. So right now, it doesn't matter that the 5th is a Sunday. So if it passes, so let's say it's effective, like, okay, the Fifth Circuit says it's effective, it'll be effective on that day, on the 5th.
Yeah, because it's 30 days. It's 30 days from when the standard was written. So if you have employees working on that Sunday, it would be it would be applicable to those people and any employees after that. So it's the way that the way it's 30 days post the event. So you're going to get into the nitty gritty. It is the 5th, even if it's a Sunday. They don't.
Right.
It's a work day for many
right.
people. I mean,
Correct.
retail,
and
anyone else.
Right. Right. So again, this is the federal OSHA standard that is on hold if you're in California. Now, if you're out of California and you have a state that has an emergency temporary standard, that's what the ETS is, emergency temporary standard. As Steve said, the last one we had was an 83 for heat illness because so many people were dying. We have not had an emergency temporary standard since then. So OSHA, OSHA is OSHA, Occupational Safety and Health Administration. And so I just want to make sure we're really clear. A lot of questions, again, about antigen testing and those sorts of things. You're going to need to look at the standard. We've gone over it. And again, the testing and the antigens and the at-home PCR test only is effective if the OSHA standard passes. So I've given the link for the CalFax. And
Kathy, let me make a note on that. It's very important from a testing perspective. The ETS does describe the specific test that they will accept, but everybody has to be very aware that starting in January, the testing, the FDA has asked the testing companies that by January 1 to change their testing procedures, that the current testing methodology is not correct. This ETS is written for the testing that's done now. So for everyone that's asking testing questions, you've just got to stay close to this from that perspective. If this comes into place, which we don't know if it will, it's in limbo. There's a 50-50 chance this come into place. But if it does come into place, then you're going to have to take another look at this. Right now, the fact sheet shows, what they'll accept and what they won't. But we have to be acutely aware that as of the beginning of the year, when the FDA makes these mandates to the changes in the testing, that all that OSHA is probably going to say is these testings have to be in compliance with the FDA testing standards, i.e. CDC is using FDA standards. So we don't want to go too deep into that process at the moment, because if you have a company that's mandating now, then you're already using the testing standards that are existing in your state. We already talked about some of the states, Illinois, Washington, California, Kentucky. Many of these states already have testing mandate procedures in place. Some counties have them, like Los Angeles and others, where there are already standards in place. So you've got to go to those particular standards to be real clear on what's going to be allowed and what's not. From a federal perspective, I think it's still to be determined, especially once the testing protocols change in January. And we're still waiting for some of this stuff. So I hope that helps explain it a little bit. And anything else, Kathy, that sort of pops up as we're just a few minutes past the hour, or should we answer them all via our email post event? And I believe you're on mute.
Yeah, I didn't want to have you hear me type. I think most of them are on the testing. The state plans, again, you need to see what state you're in, and if you are in a state plan. One of the first slides Steve showed was what states have what plans.
Right, and
so one question, and Steve, this is a good one. Wondering who is administrating all this in companies. We don't have an HR department. We don't have a full-time admin. Who is picking up all these responsibilities? That's a really good question, and it could be anyone. I know of some companies that have actually just hired people to manage their COVID plans. It's very difficult for small companies.
Yeah,
it can be outsourced.
Right. Some companies are offering a full-on plan. If you were to talk to a CVS or any of these, organizations, or your local or your healthcare occupational company, they'll assist you. some of these are just taking on the testing. From an administrative perspective, like who's going to be tracking all of this, at 100 employees or more, most companies have got someone that's either in legal or operations or HR or somewhere in those categories. So, and if you're smaller than that and your state happens to not care whether it's 100 employees or more, then you're right, that does becomes a challenge in managing that. That's a tough one.
And I think one last thing, Steve, and then any of these you can go through, is the 100 employee threshold at the end of May or 6 months after December 6th? Remember, it's 100 employees at any time once the standard becomes effective. And so whether you're a staffing company and it fluctuates 50, 100, 75, if at any time you have 100 employees as soon as that program is effective, that's it's applicable. This is the Fed OSHA standard.
Right.
So
it's like Hotel California. It's like Hotel California. You can check in, but you can't leave. If you get into the ETS, you cannot get out, because if you have 100 employees, in any capacity at any time, you qualify. So you could be on, May of 2022 and be in a situation where, we just hit the 100 employee mark. Well, yeah, conceivably for those remaining 30 days, you've got to be in compliance. I think the thing that most everyone is aware of is that this is it's a moving standard. We don't know if it will be completely stopped, or aspects of it will come back in a separate ETS, or what your states will do. It's just, we can't emphasize enough that if you're not familiar with your state ETS, you've got to look it up, because they are making decisions within the next couple of weeks on what they plan on doing. Like I said about Washington State, watch what your governor may do. He's already indicated that they're going to go ahead with their ETS and make it more strict than this. Now, yes, they can have, somebody try to, impede that, but you've got to be aware of your state and where they're at. And the best way to do that is through either those channels that we recommend, or go to your local state OSHA page and watch for their updates. If they have, board meetings, be a part of it. I know it's crazy. We have enough things to do besides paying attention to this, but it is critical. I'll make one last comment. In the standard, they say that there's going to be flexibility for employers. They're not going to come down like on day one to go after everybody. They're going to offer some flex. So I think from that perspective, you'll have a few weeks to be able to get things sorted out. Okay,
yes,
Kathy?
Yes, sorry. And I just to clarify, and the question is, if the Fed ETS comes through, then we follow that over the California ETS. That is correct, because it is more stringent than the California. But right now, California is in place. But you're right. California typically would have 30 days to meet that in their own state plan, and until they do that, you'd have to follow the Fed OSHA plan.
That's great. So Kathy, we'll take any remaining questions, put an FAQ together in our response, and I want to thank everyone for staying around the extra time. Appreciate you being a part of today's webinar. Thank you to Heffernan clients and members of their team so much, and have a wonderful day and an incredible Thanksgiving, and we bless you all. Take care.
Thank you, everyone. Thanks for everything. Thanks, Steve.